Hello, good afternoon, everyone. Welcome to this lecture series on the rules on criminal procedure. This is part 7. We will discuss the rules on bail. Now, let me share my screen with you. Okay. Now, rule 114, bail. Now, first, what is the definition of bail? Bail is the security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions prescribed under the rules. Now, based on the definition of bail, bail is a security. No? It is a security for what purpose? That security posted by the accused is to secure or guarantee his release, no? Or temporary release of his person. Now, according to Section 1 of Rule 114, that person who is posting a bail is in the custody of the law. What do you mean by the term in custody of the law? In custody of the law means that the person posting bail, it's either in detention with the police detention cells or detention centers or the jails, or when the accused voluntarily surrender in the court. So under these two instances, when a person is arrested and detained by police authorities, and when the accused voluntarily surrenders his person to the authority of the court, then that person is said to be in custody of the law. Now, class, if you go into the practice or your practice, no, you will notice that one of the requirements before the accused can post a bail is what? There must be a certificate of detention to be issued by the PNP or a certificate of voluntary surrender. Now, why these requirements are mentioned among those necessary documents? Now, the reason is that Rule 114, Section 1 requires that a person posting a bail must first be in the custody of the law. A person who is not in custody of the law may not post bail. Why? Because if you are not in custody of the law, then there is no reason for you to secure your temporary release because you are not in any way restrained by or to your person. Now, based also on the definition, a bail can be furnished either by the accused or by a bondsman. No, there are two kinds of bail. It can be furnished by the person seeking release himself or a bondsman, or a third person. Now, the posting of a bail is with the end view that the appearance of the accused will be guaranteed with the court as may be required under the rules of court and as may be ordered by the court. Now, if you read the entire rules on civil procedure, there are 3 instances wherein the accused personal appearance is required. Now, what are those? Number 1, during arraignment. No? During arraignment, when the accused is presented before the court and the information is read to him, the personal appearance of the accused is required. No? What else? During identification. When you say identification, the witness for the prosecution will have to point out to the person of the accused. That is what we mean by identification. And then third, during promulgation of judgment. Under these three circumstances, the personal appearance of the accused is required. And therefore, if a person is released on bail, then he is required to appear in those circumstances. Because under those circumstances, the rules of court demand the personal appearance of a person released on bail. Now, what is the basis of the right of the accused to post bail? Where is this right coming from? The right to bail is a constitutional right which flows from the presumption of innocence in favor of every accused who should not be subjected to the loss of freedom. Now, whenever a person or an accused posts bail, that right belonging to him is enshrined under the Constitution. Now, what is that constitutional right enshrined in the Constitution? That right is called presumption of innocence. Ano bang ibig sabihin niya in class? Presumption of innocence means that every person is presumed innocent until proven otherwise. Now, the right to bail only accrues when a person is arrested or deprived of his liberty. No? The right to bail presupposes that the accused is under legal custody. Now, for example, if the accused is at large, ano ba yung sinasabing at large, class? When you say at large, he did not voluntarily surrender to the court or he was not arrested. No? If the accused is at large, then can he post bail without voluntary surrender or without presenting himself to the court? In other words, can he post bail through a representative, for example? Can that be allowed under our rules on criminal procedure? The answer is no. The right to bail presupposes that the accused is under legal custody. Without voluntary surrender, without arrest or detention, then the accused may not post bail. Now, if a person has successfully granted bail, no, are there conditions? Answer yes. First, there must be an undertaking. No? And that undertaking shall remain in form at all stages of the case until promulgation of the judgment of the regional trial court. No? That the accused shall appear before the court whenever required by the court or these rules, referring to the rules on criminal procedure. So these are the conditions, class. Number one, the accused must execute an undertaking. An undertaking is a statement. It is a warranty or promise of the accused that he will appear personally before the court whenever required by the rules or by the order of the court. Now, for example, the accused failed to appear at the trial without justification and despite due notice. What is the effect? That failure to appear on the part of the accused shall be deemed as a waiver of his right to be present thereat. And therefore, the trial may proceed in absentia. Yan ang tinatawag, class, na trial in absentia. That means that the accused opted to waive his right to be present in the proceedings and participate therein. Now, the bondsman shall surrender the accused to the court for execution of the final judgment. No? Okay? So, class, no, the original papers that will have to be submitted to the court, no, these are among the requirements in posting bail. No? The accused will have to state his full name, address. As a matter of fact, there is also a house sketch No? And then the amount of the undertaking and the conditions required by the rules. The accused is also required to submit photographs in passport size taken within the last 6 months showing the face, left and right profiles of the accused must be attached to the bail. So these are the requirements under the rules of court. But mind you, class, when you go into practice, there are different requirements of courts. No, sometimes the requirements of the court in posting bail will vary from jurisdiction to jurisdiction or from executive judges to another. No, so hindi uniform ang requirements. No? Now, halimbawa, merong surety or bondsman na tinatawag or bondsman. For example, the accused has no financial means to pay the cash bond. No, the accused can obtain a surety bond. A surety bond is where a third person will guarantee the release of the accused on the condition that if the accused fails to appear, then the surety or the bondsman will have to pay the amount of the cash bond. No? Yan ang condition niyan. The liability of the surety or bondsman is civil in nature. Now, when you say civil, it consists in payment of a sum of money and it emerges from a contract. No? Okay. Now, for example, the offense is not bailable. No? May mga offense na bailable, may mga offense na non-bailable. Now, if the offense is bailable, then you will see in the resolution or the information the recommended bail by the public prosecutor. Pag bailable yan, nakasulat na dyan ang amount ng bail. And all you have to do is to pay the amount and submit the necessary requirements. No? Now, if the offense is non-bailable in nature, then can the accused post or file a post bail? Can the accused post bail even if that offense that he allegedly committed is non-bailable? Answer yes. The remedy of the accused is to file a petition for bail. No? To file a petition for bail before the court that hears or tries his case. Okay? Now, what is the nature of bail proceedings? The hearing of an application for bail should be summary or otherwise in the discretion of the court. Kaya sinasabi ng mga huwes class, a bail proceeding is summary in nature. No? What do you mean by the term summary? When you say summary, it must be expeditious. Mabilis. It is supposed to be continuous and expeditious. Meaning, it will not allow several postponement. Now, because by nature, a bail proceeding is summary. Okay. Now, what are the purposes of bail? Number one, to relieve an accused from rigors of imprisonment until his conviction, rather, and yet secure his appearance at the trial. So before the accused is adjudged guilty of the crime charge, then he has the right to secure temporary release or freedom. Now, bail is also to honor the presumption of innocence as enshrined in the Constitution. It is also to enable the accused to prepare his defense without being subjected to punishment prior to conviction. Kasi class, it will appear that while the case is being tried and the accused is detained, it would appear that he is being punished of a crime to which he was not yet convicted. So to enable the accused to prepare his defense then he can avail of his right to post bail. Now, there are 4 kinds of bail. The most commonplace is cash deposit or cash bond. Ibig sabihin, kapag 30,000 pesos ang piyansa, bayaran mo sa 30,000 pesos, then you can post bail. But there are other kinds of bail. There is what you call corporate surety or bail bond. There is also a property bond and recognizance. What is a corporate surety or bail bond? A corporate surety or bail bond is an obligation under seal given by the accused with one or more sureties and made payable to the proper officer with the condition to be void upon performance by the accused of such acts as he may be legally required to perform. Now, what happens, class, in a corporate surety bond or bail bond is that the accused goes to an authorized bonding company and he will pay what you call as a premium for the service. Now, what is the advantage of a corporate surety or bail bond? In such a kind of bond or bail, the accused will not pay the entire amount of the bail or the recommended amount of bail. Instead, the accused will only pay a premium, and that premium is only a small percentage of the total amount of bail, which is why I earlier mentioned that a corporate surety is resorted to if the accused lacks financial capacity to post a cash bond. Now, if the accused jumps bail or if he skips hearing despite notice, then the bond will be canceled and then the bonding company will be given sufficient time to locate the whereabouts of the accused who posted bail but later on jumps bail. Now, notice to bonding company is notice to the accused, no? But if the bonding company will fail to locate the whereabouts of the accused, then the court will cancel the bail and issue a warrant of arrest. So that is what you call as corporate surety or bail bond. Now, the third type of bail is a property bond. By its term, a property bond, the title of the property will be used as security for the provisional liberty of the accused, which shall constitute a lien over the property. When you say lien, it is an encumbrance or a burden. Now, in a property bond, the accused shall cause the annotation of the lien within 10 days after the approval of the bond. No? This annotation, no, ano bang ibig sabihin ng annotation, class? That bail will be inscribed or annotated at the back of the title before the registry of deeds if the property is registered, and the registration of books in the registry of deeds of the place where the land lies, and before the provincial, city, or municipal assessor on the corresponding tax declaration if the property is not registered. Okay. Now, third is cash deposit or cash bond. No? This is very easy to understand. Now, in a cash bond, if the accused does not appear when required by the court or by the rules, then the whole amount of the cash bond will be forfeited in favor of the government, and that the accused will now be arrested. Now, what is the last type of bail? Last type of bail is called as recognizance. Recognizance is an obligation of record entered into before some court or magistrate duly authorized to take it with the condition to do some particular act. It is an undertaking of a disinterested person with high credibility, wherein he will execute an affidavit of recognizance to the effect that when the presence of the accused is required in court, the custodian will bring him to that court. Now, a recognizance class, there is no property, there is no cash or surety which is being brought or paid to the court. Instead, a recognizance, this is an undertaking of a credible person, or what we call as a custodian. In other words, class. The temporary release of the accused will be entrusted to a credible person who has no interest in the case. Now, in case that the court requires the presence of the accused, the custodian will have to bring the person of the accused to attend the hearing. But recognizance class does not apply to all kinds of offenses. Recognizance is available only or is allowed only for light felonies. Now, you may ask, where do you file your bail? Now, where do you file bail? Now, number one, you can file it in the court where the case is pending. Now, if the court has been filed in a particular jurisdiction, then you can only file the bail in that court where the case is pending. But can you file a bail to another court or before another court? Answer yes. You can file it in the RTC or the MTC. Now, in the absence or unavailability of the judge thereof, the accused can post bail before the RTC judge or MTC judge or MCTC judge in the province, city, or municipality. Now, when bail is filed with a court other than where the case is pending, then the judge who have accepted the bail shall forward it to the court where the case is pending. Okay? On the other hand, if the accused is arrested in a province, city, or municipality other than where the case is pending, then bail may also be filed with any RTC of said place, or if no judge thereof is available, with any MTC or MCTC. Okay? But if the accused or a person in custody has not yet been charged in court, then he can apply for bail in any court in the province, city, or municipality where he is held. So I will review. Number one, you can post bail in the court where the case is pending, or you can post bail in any RTC, MTC in case of absence or unavailability of the judge. And then third, if the accused is arrested, it can be filed with any RTC of the said place or any MTC, no, where he was arrested. But if the accused has been arrested but there is no charge yet in court, then it can be filed in any court in the province, city, or municipality where he is held arrested. Huh? Okay. Now, when a person now is lawfully arrested without a warrant, asks for a preliminary investigation, then he may apply for bail. Kasi ganito yan, class. Diba? Kapag ka nahuli yung akusado in flagrante delicto or in instances justifying arrest without lawful warrant, then the proceedings will not be preliminary investigation but inquest. But during inquest, class, the accused may ask for a preliminary investigation in order to secure a more thorough proceedings. In that case, when the accused asks for a preliminary investigation, then he can apply for bail. Now, class, meron tayong tinatawag ng mga juvenile delinquent. No, yan ang tawag dati-dati. Pursuant to Republic Act 9344, Juvenile and Justice Act of 2006. Now, ang tawag na ngayon natin dyan, hindi na sila mga juvenile delinquent because it is kinda discriminating. Ang tawag na ngayon ay child in conflict with the law or CICL. Kapag ang akusado ay minor de edad, ang hindi akusado ang tawag sa kanila. Ang tawag sa kanila ay child in conflict with the law, CICL. Now, kapag ang akusado ay CICL, pwede siyang makapag-bail by release of on recognizance. Now, where a child is detained, the court shall order the release of the minor on recognizance to his parents or and other suitable persons. Okay? Release of a child in conflict with the law on bail or transfer of the minor to a youthful detention home or youth rehabilitation center. Yung mga bahay pag-asa, no? Youth detention home. Now, if the minor is unable to post bail, then he can be committed to the care of the DSWD or a local rehabilitation center or upon recommendation of the DSWD. No? Okay. Now, if a military person has been accused of war crimes or violation of the articles of war, then he does not have or he does not enjoy the right to post bail. No? Okay. Now, as a general rule class, bail may not be filed once there is already a final judgment. Pag tapos na ang kaso at na-judge na guilty ang akusado, hindi siya maaaring makapagpiyansa. Except, even after conviction by the MTC, bail is still a matter of right. As a matter of fact, class, pagka ang akusado ay na-convict at nag-apply siya for probation, he may be allowed temporary liberty under his bail. Okay? Bail is a matter of right before or after conviction by the METC, MTC, and before conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, or before final conviction by all children in conflict with the law for an offense not punishable by reclusion perpetua or life imprisonment. No? Okay. On the other hand, bail becomes a matter of discretion upon conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment. Regardless of the stage of the criminal prosecution, a person charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment when evidence of guilt is not strong. Okay? Now, bail should be filed with the trial court despite the filing of a notice of appeal, provided that it has not transmitted the original record to the appellate court. On the other hand, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, then bail may be filed with the appellate court where the case is pending. Okay? Okay. Now, what are the duties of the trial judge if an application for bail is filed? Now, the trial judge will have to decide whether the evidence of guilt of the accused is strong based on the summary of evidence of the prosecution. If the evidence of guilt is not strong, then the court will have to allow the accused to post bail. Now, who has the burden of proof in bail proceedings or bail applications? It is the prosecution who has the burden of showing that the evidence of guilt is strong at the hearing of an application for bail. No, tandaan nyo, class. Pag ang akusado ay nag-file ng petition for bail, the prosecution has the burden to prove that the evidence of guilt is strong. Kaya ang una nagpe-present, class, sa bail hearing ay ang prosecution. Kasi siya ang mayroong burden of proof. No? Okay. Now, if a bail is granted, the accused shall be released upon approval of the bail by the judge. Now, what if the petition for bail filed by the accused has been denied by the trial court? What if the court denies the petition for bail? Then the accused can file a petition for certiorari under Rule 65 based on grave abuse of discretion amounting to lack or excess of jurisdiction. Okay? Now, if bail is granted by the court, then the court has the duty to fix the appropriate bail. No, magkano ba ang piyansa? Now, depende ito, class. The prosecutor will have to give his recommendation regarding the following. Number 1, the financial ability of the accused to give bail. No, kailangan isaalang-alang kung may kakayanan ang akusado na magpiyansa. Number 2, nature and circumstances of the offense. Kung mabigat ba ang akusasyon o ang demanda. Number 3, penalty for the accused. Mabigat ba ang parusang inaatang na maaring igawad sa kanya o ipataw sa kanya? The character and reputation of the accused. Age and health of the accused. Mabigat ba ang ebidensya laban sa kanya? No? Is there probability of the accused appearing in trial? Etc. etc. No? Now, bail is not required for violation of an ordinance, light felony, or criminal offense with an imposable penalty not exceeding 6 months of imprisonment and or 2,000 pesos fine. So kapag ka ang parusa sa krimen ay 6 na buwan at pababa o kaya naman ay multa na 2,000 at pababa, then bail is not required. Okay? Recognizance is already sufficient. Okay. Now, for example, nabawa, nakakulong ka and then yung number of years na nakakulong ka ay equivalent sa minimum of the imposable principal penalty, then you can be allowed to be released on bail. Okay? Okay. Now, if the accused does not have the financial ability to post the bail initially fixed by the court, halimbawa, class, walang pera ang akusado, hindi niya kayang bayaran yung amount ng bail, ano ang remedy niya? The accused may move for its reduction by submitting documents and affidavits that may warrant his claim for reduction. So, pwedeng mag-file ng motion to reduce bail ang akusado. Pero kailangan niya mag-submit ng dokumentong nagpapatunay na wala siyang kakayanan na magpiyansa sa ganong kalaking halaga. At maaari din namang mag-file ng affidavit to support his claim. Now, ang bail hearing, class, under the Supreme Court circulars enjoy priority in the hearing of cases. Inuuna yan, no? Kasi nga summary in nature. Okay? Okay. Halimbawa, nag-decide ang husgado na payagan ang akusado magpiyansa. Question, maari bang mag-apila ang prosecution? According to Section 4 Administrative Matter number 12-11-2 Supreme Court, the order fixing the amount of bail shall not be subject to appeal. So, hindi pwede. No? Now, once the accused is granted bail, maari ba itong ma-forfeit at makansela? Yes. Halimbawa, no? The bondsman failed to produce the accused within 30 days. No? Or there is automatic cancellation of bail when there is acquittal of the accused, dismissal of the case, and execution of judgment of conviction. So this ends our presentation on the rules, Rule 114, bail. I'll see you again next meeting. Thank you and goodbye.